Judges in a common law process, or the jurisconsults in the Leoni process, the law leaves you alone unless you ask the law to help you. The law leaves you alone unless you invoke the judge to resolve a dispute that has risen between you. So that basically you can go about your business, and if everything works fine, you never have to call in the state. The second thing he notes is that by definition and by design, the judge or the consult or whoever decides the case, their law is literally limited only to the facts of that case in your dispute. It conceptually has extension to other cases, but it literally just applies to your particular dispute. What does that mean? It means that you're bound by it, others are not necessarily, but embedded in the common law, and this is an idea I got from my old professor, Bob Staff, is the ability to contract around the common law rules, which is common law rules are there as inputs into people's decision making, but if you don't like them, you're always allowed to contract around them and design different sorts of rules for yourself. Which I think is consistent with the idea that Leoni has here, which is that it is individual decisions. The individual choice to invoke the state is what calls the government into it. And this is, I think, to some extent, what he has in mind with this passage that Roger described of a spontaneous order and a market analogy that basically that it's this sort of back and forth between individuals making individual claims, judges resolving them, and that coming back in as an input into people's decision making. He contrasts this with legislation, which is enforced on everyone. So for instance, you and I could enter into a contract for me to have you come work at my shop. And we could contract about the terms and the rates and everything else. The very definition of a minimum wage is that I'm not allowed to contract with you in a way that both of us find advantageous. Legislation is by definition binding on everyone, basically. It basically forces us, and it acts on us whether we wanted to or not. And that gives rise to a lot of rent-seeking problems and that sort of thing. And in fact, Leoni himself was an early adopter of public choice. You see public choice in the understanding of the legislative process in a very well-developed form here. Calculus of consent was 1967, for instance, right? So Leoni is very much an earlier adapter of this. He contrasts that process where legislation acts on people, whether you want it or not, with the common law process. And we referred to this earlier, the notion, he has this key idea where he talks about that the way the common law works is that judges seek to discover the law. And so he said both the Roman and the English shared the idea that the law is something to be discovered more than to be enacted, and that nobody is so powerful in society as to be in a position to identify his own will with the law of the land, unlike a legislature or apparently now a president. And what does he mean by this? This is often misunderstood in Hayek and misunderstood in Leoni. And it's this notion of finding the law in discovering law. What do they mean? The common law, and I'm going to just use common law as a shorthand to describe it here, is a conceptual system. The law of the common law is a conceptual system for which the articulation in judicial decisions are verbal attempts to articulate the underlying concepts, but it's the concepts of the common law that are the law, not the precise linguistic choices of judges. Now, why does this matter? It matters for a couple reasons, which is first, modern law has that confused. Modern law school, through the doctrine of stare decisis, thinks of the precise verbal articulations by judges as being the law. Why do they do that? Because they have this flawed positivist concept that comes borrowed from legislation that basically says, well, legislatures make the law and judges make the law when they decide cases. Judges decide cases, but the logic of the common law was it was conceptual, it was the underlying logic. Where did those concepts come from? They basically came from the spontaneous process of individuals making claims, having judges resolve them, leading to other individuals making claims, leading other judges to resolve them, and this back and forth, this iterative sort of process. So, for instance, Leoni criticizes Supreme Courts as a bastardization of the common law process. Why? This will sound familiar, at least to some of us. The Supreme Court seems to sometimes think of itself as a super legislator, imposing itself on society and binding other parties, whereas Leoni said that's not how this works. It was a back and forth, multiple different courts borrowing from each other and people responding to it. He also has a very flexible view of precedent. Not the modern view of stare decisis, where one case makes the law, but precedent is a pattern of cases decided by individual judges persuaded by their logic. Now, why does this matter? This is the most important idea that comes out of Leoni, and the most provocative, is that what this all means is that the common law is less uncertain than legislation. That the common law is less uncertain than legislation. And what he does is he draws a distinction between what could be called, what he calls short run and long run certainty. So he says, while legislation is almost always certain, that is precise and recognizable as long as it is in force, people can never be certain that the legislation enforced today will be enforced tomorrow or even tomorrow morning. The legal system centered on legislation, while involving the possibility that the other people the legislatures may interfere with their interactions every day, also involves the possibility that they may change their way of interfering every day. As a result, people are prevented not only from freely deciding what to do, but from foreseeing the legal effects of their daily behavior. Raise your hand if this sounds like something you may have read in the newspaper recently, right? And this is the underlying point in which Leoni in the common law goes together with Pete Boettke's observations, which, if it is true, legislation, and even worse, we see now administration, or a president who says, I have a pen. Lawmaking by blog post and press conference. I'm sure Mr. Leoni is rolling in his grave whenever he sees this, right? Which is his point is, because common law is conceptual, because it evolves out of people litigating concrete disputes where frictions arise in their life and leaves people alone when it doesn't arise in their life, because it articulates these concepts to people, it may be somewhat unclear in the short run who is in the right, or in an immediate case, but over the long run, it comports with people's expectations. Compare that to the modern legislative and administrative state, which he very accurately says the law today may not be the law tomorrow. And in fact, as we've seen, the law this morning may not actually be the law this afternoon if there happens to be a presidential press conference.